Okay, so good afternoon, everyone. We'd like to thank you for your interest in the event. We're extremely happy to share with you the first URGS IOGEL Clinic webinar for the year 2021. Firstly, we, the moderators, shall present ourselves, speak briefly about the URGS IOGEL Clinic's work, and then present tonight's Dr. Yael Vias. We would like to point out that the questions may be submitted in the chat box on YouTube, and following the guest speech, we will move on to the questions. And with this being said, I will start presenting myself. I am Isabel Marcondes, Bachelor of Law by URGS and the head coordinator of URGS IOGEL Clinic.
And I am Ellen Kurossi, recently graduated in law from the Toledo Prudential University Center, and I act as a legal assistant at the clinic.
So as per usual, while we wait for the viewers to join the live stream, we would like to give a brief explanation on what is the URGS International Humanitarian Law Clinic. We are Brazil's first IOGEL clinic and serve as a center for learning, research, and legal consultation on international humanitarian law matters. We work on many different areas related to the study and dissemination of the IOGEL, such as events and webinars as this one, in order to disseminate the knowledge of IOGEL with the general public. We also do research and academic productions on the area, such as cyber law and armed conflicts, our current research project. We also participate on international moot courts, and we are hosting our own national IOGEL monograph competition alongside with the ICRC. So, and as the last area, we also participate in international law classes as special guests within the URGS University.
So today's webinar concerns the issue of business and human rights in the context of armed conflicts, focused on the responsibility of corporate actors for serious violations of human rights in the Iraque chemicals weapons case. So with that being said, we have the honor of having with us Dr. Yael Vias. She is an attorney on French in Israel and served as an expert in domestic litigation on civil and business related issues on French law, and also served as amicus curiae to the International Criminal Courts. She is a member of the International Law Association on the Committee on Complementarity and co-author of Israeli ICC reports. She is part of the board of directors, executive secretary, and co-founder of ALMA, Association for the Promotion of International Humanitarian Law. She served as a prosecutor at the State's Attorney Office in Jerusalem. She worked as eligibility or legal officer at the United Nations High Commissioner for Refugees Office at Tel Aviv. She worked as an associate researcher at the law faculty of the Hebrew University and completed her legal traineeship at the Office of the Legal Advisor at the Ministry of Foreign Affairs in Jerusalem. She also completed her internship in New York at the Office of the Coordination of Humanitarian Affairs at the UN Secretariat. Yael is the founder and current director of the first and only international criminal and humanitarian law clinic in Israel.
Thank you.
Yes. So we are very honored to receive you today. Thank you for sharing with us your knowledge on this very interesting topic. And without further ado, welcome, and you have the floor.
Thank you very much. Thank you, Isabel Marcondes, and thank you, Ellen, and thank you, Raquel and Mariana, and all of the team of the IHL Clinic. Thank you very much for the invitation. I'm very happy to be with you today. I'm joining you from Tel Aviv, so this is maybe the only advantage of COVID restrictions, that we can reach out from afar, and actually we can, from Tel Aviv, we can connect until Brazil. So I'm very happy to be with you here, my evening, your afternoon. And thank you for the public's interest and for whoever is connecting with us. I will try to, what I will attempt to do today is to speak with you about the intersections between international humanitarian law and business and human rights, two independent fields: international humanitarian law, IHL, and business and human rights, which I will refer to as BHR. So Ellen is the master of the PowerPoint, so if you can please move forward, we can share the screen. Wonderful. And if you can please move forward to the next slide, which will happen in a sec. In the arrows, yes, perfect. So, right, so what will we talk about? First, we'll talk about, I'll give a very brief introduction to the International Criminal and Humanitarian Law Clinic, which sits at the Harry Radzner Law School, IDC Herzliya. And I would like to congratulate our sister clinic at the Federal University of Rio Grande do Sul, which I understand was established in 2019, which is wonderful news for us at the IHL clinic community. We're always very happy to have have the good news of a new clinic joining us, and there's a lot of work to be done and cooperations to weave in together, and each clinic has its own specialities. So this guest lecture, I understand, is just part of the beginning of our cooperation, and I'm very, very looking forward to it. After introducing briefly the International Criminal and Humanitarian Law Clinic, which I call briefly the ICHL Clinic, I will briefly present the Business and Human Rights branch within the clinic that was established about 3 or 4 years ago. And finally, I will reach the main topic of our lecture today on the intersections between IHL and BHR. I'll provide a general framework and present case studies. I understand that this lecture is one in a series, and that next week, perhaps, if I'm not mistaken, on 1st of July, you'll be hosting Dr. Jelena Aparach, who will be speaking on private militaries and their accountability in armed conflicts. So I will only mention this topic without going into it, and I will leave Dr. Aparach's, I will leave you with her expertise to know more about that. Just a little caveat, thank you for the presenters, but I'm not yet a doctor, so thank you for the promotion. I'm an attorney specializing in international criminal law, and it's true, as you said from my bio, I move between practice and academia. So first, the International Criminal and Humanitarian Law Clinic. The ICHL Clinic really allows me to do what I like best, which is what I said a second ago, which is to jump between academia and practice. The clinic bridges between the two worlds, and it exposes law students in Israel to the topics that we all hear about in the news, in the mouths of politicians and so forth, topics that it's a reality. They affect all of us here. The ICHL Clinic, IHL Clinic is one of the only ones that operates in a conflict situation. And so the students are all affected by conflict in one way or the other. Other IHL clinics are based, there are others that are based in conflict zones, but most of them are based in, I'll call them neutral zones, and then they can be the home of students of mixed backgrounds, some coming from conflict areas and some coming from non-conflict areas, which is a very good combination because each person individual and professional can bring their own perspective. So the International Criminal and Humanitarian Law Clinic is based at the Harry Radzner Law School. I don't know if your clinic is based in the law school. I think it's a very important base to have for an IHL clinic. Okay, wonderful. Within the Interdisciplinary Center, IDC Herzliya. Herzliya is 20 minutes north of Tel Aviv. It was established in 2014 out of the need or the identification of a gap in education, in practical education within the environment of academia. So it's the chance to provide students with legal tools to deal with legal questions that also have that also have political aspects and communicative media aspects But in my view, and I think anyone sort of embracing international humanitarian law or international law in general, these are legal questions that have legal answers. And so the idea is to provide students with legal capacities, legal tools to sort of to solve not solve the questions, but to approach these questions and to understand the different discourse held by academics and practitioners of all fields. The way we study is we learn about our conflict, but we also learn about different conflicts and the role of law within different conflicts. The clinic has two speeds. One is a theoretical branch where it's an actual course for the entire clinic. The number of clinic students, they're all enrolled in law studies, but they're also doing another degree in parallel. The number of students varies from year to year. We've had 30 students, and this year we have 15 students, 15 wonderful students. So one speed is the theoretical branch where students do an ICC, an internal clinical ICC moot court. We meet weekly. We have debates on topics that are in the front line of the topics that the clinic deals with. We study international humanitarian law and we study international criminal law. International criminal law is the application of grave breaches or violations of international humanitarian law, but also the application of gross violations of human rights. So these two topics, fields, international criminal law and international humanitarian law, are interrelated. When one is the enforcement branch of the other, and this point will be of relevance throughout my lecture. I'd like to add something, is that I welcome questions. I'm going to talk. I'm almost through introducing the clinic and the BHR branch. And once I speak about the actual topic that brings us to questions, I'll talk about it for about 30 minutes. And you can either save questions till the end, or you can feel free to ask questions. We have our moderators here who are sending me your questions live in chat. And if I miss something, they'll call my attention to it. Right. So alongside the theory, students also do practical work. In teams, they work with or vis-a-vis practitioners who are from different fields. It can be international organizations, international criminal tribunals, intergovernmental organizations. Just as you're going a bit too quickly, Ellen, we need to go back with the PowerPoint. Thank you. They do practical work, working with the ICRC, governmental bodies, civil society, victims of international crimes, including asylum seekers. So really a whole range. And the idea is to, throughout one academic year, our clinic is throughout the whole academic year, and sometimes actually a calendar year, to expose the students to as many actors, as many conflicts, as many legal sort of solutions or options that law has to offer in conflict situations. Okay, so that was really a word about the ICHL clinic, and now we can move forward to the next slide. We need to move forward to the next slide, to the BHR branch. I took the photo from the UN Forum, which meets on business and human rights, which meets yearly in Geneva. So this is not my photo, but it's used for academic reasons, and I don't want to violate any copyright rights. Good. So what is the business and human rights branch within the clinic? It is the fact that within the practical experience that students have throughout their time with the clinic, they work in teams on vis-a-vis external partners on different projects. So I brought 3 examples. We had one project where we did a comparative study of about 10 different jurisdictions, continental law and common law jurisdictions, on corporate liability. We did this with an NGO, a civil society member that is linked to the IBA, the International Bar Association. And the questions we had to answer was, how are corporations liable in different jurisdictions for violations of international human rights law, international humanitarian law? This was one project. Another project was vis-a-vis the UN Global Compact, which sits also in Geneva. It's sort of, it's a very big network of thousands of practitioners, governments, corporations, of course, that apply the UN guiding principles on business and human rights. And it has a core secretariat, a very few number of people who sit and do wonderful work across the globe. And so it's wonderful to have, hopefully it's wonderful to have local actors to sort of support their work. So that's something an IHL clinic working on BHR can do, business and human rights. So it's field work. And what our students did were to reach out to corporations who have signed up to the UNGPs, the 2011 UN Guiding Principles on Business and Human Rights, and to do surveys in relation to questions asked by the UN Global Compact team. A final example I thought of is actually a project we're working on this academic year, on a domestic law proposal for zero exploitation in the supply chain. Some would call it fair trade. So exploitation really means exploitation is really the joint element, the common denominator in international law definitions of slavery, of human trafficking, and so forth. And so we want corporations to act responsibly, not only within the borders of a state, but also when they act across border. And as we know, globalism brings us cross-border economic activity, and we want that economic activity, including in the supply chains, first of all, to have zero exploitations, including worker rights, and of course, from the, let's say, from the, I'll call it the lowest, most common rights in peacetime, but until the gravest breaches, so that all this is avoided within the supply chain. If we can move forwards, please, with the PowerPoint, Helen. And thank you very much for being wonderful. So we've reached our topic. Our main topic is the intersection between IHL and BHR. We'll start by, I'd like to touch upon 5 points that you see listed here in the PowerPoint. We'll talk about the what first of all, definitions, what is IHL, what is BHR, and then what, meaning when do they meet? That's our second point. When do corporations, when are they involved in anything that has to do with a normative framework called international humanitarian law? I'll give you a teaser. It has to do with armed conflict, mostly. Then we'll deal with how, it says here actually how to act against it, but we'll first deal with how are corporations involved in violation of rights and international humanitarian law within conflicts, and also how to act against it. I'll touch upon 2 points on how to touch against it, which actually reflect the vision of BHR, business and human rights. The first vision has to do with prevention. So we're talking about soft law and binding law that have to work together in a complementary way. We talk about voluntary actions by corporations when they adopt, for example, ethical codes in their activities. For example, the the most recent example in March 2021 by Facebook and its human rights policy, just as an example, and education. So all this is within prevention. I'll give a few examples of active examples from practice on how these sort of voluntary commitments act to prevent violations related to in the intersection of IHL and BHR. And finally, we'll touch upon protection and remedy, which has to do with after crimes are committed or after violations are committed. This has to do with litigation, both civil and criminal law, and victim representation. We'll talk about a case study including a case study that I am personally involved in. So Ellen, if you can please move forwards with a PowerPoint to our next slide. Thank you. Okay, so our first point is the what. Let's first define IHL. So we said IHL stands for International Humanitarian Law. International Humanitarian Law is the law of armed conflict and the laws of belligerent occupation. So two branches that are triggered under certain conditions. And what we need, grosso modo, is to be in the presence of an armed conflict and or in the presence of belligerent occupation, which usually the test for in customary law for belligerent occupation is effective control, but we will read the definitions together. So if we can move forward to see what this means. Great, Ellen, thank you. So, actually, no, if you can go back a little bit, thank you. So the main sources of international humanitarian law, side by side with the commentaries, the different interpretations, guidelines, etc., are first and foremost the Hague Regulations of 1889 and 1907, which are considered customary international law. This means they are binding on states even without having signed a treaty, accepting their binding. So, for example, the principle of distinction in armed conflict, only combatants and those taking direct part in hostilities can be directly targeted. Military objects can be targeted and not civilian objects. Civilian objects can become momentarily military objects by use, military use. So these are customary law rules, all inscribed in the Hague Regulations, alongside rules pertaining to belligerent occupation, answering the question of what are the duties and obligations of the military commander having effective control over a civilian population due to an armed conflict. So these are the Hague Regulations. We then have the 4 Geneva Conventions of 1949. Most of the majority of the articles in the 4 Geneva Conventions of 1949 are considered customary. As to other articles, they are not customary, or there is disagreement as to whether they are customary or not. How does custom come to be? How is a norm come to be imposed on all states even without them agreeing to it? That can be the topic of a whole separate guest lecture or other lecture. But very briefly, it has to do with what states do, so state practice, and what states think when they do, so opinio juris. So states can be violators of international humanitarian law, but they know that they're violating the law. Nevertheless, states can be applying international humanitarian law or interpreting international humanitarian law or the laws of armed conflict and hostilities, believing that they are standing by their obligations under law, and either they are or they aren't. It's a topic for debate and sometimes for litigation. Finally, we have the two additional protocols of the Geneva Conventions of 1977. The first one applying to international armed conflict between states, and the second one applying to non-international armed conflicts where only one of the belligerents is a state and the other is a non-state actor. If we can move forward now. Thank you. So we have, thankfully, in order to know when we are in armed conflicts, and in order to know when IHL applies, we have Common Article 2 to the 4 Geneva Conventions of 1949. Common Article 2 states that, in addition to the provisions which shall be implemented in peacetime, meaning international human rights law, law enforcement, the present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. So the first case scenario of applicability of IHL is when there is an armed conflict between two states. There is an armed conflict between two states, as we shall see when we move forward, the minute there is use of force between the armies of a state. So that's quite easy to define. Although, and especially if you're working on a project on cyber law, new technologies have redefined attack and redefined armed conflict even, including under cyber attacks. So of course, even that is challenging, even armed conflict between two states. The second scenario is IHL applies, so the first scenario applies to international armed conflict. The second scenario is when there is belligerent occupation. So this is how it's drafted by the drafters of the Geneva Convention. The convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. So when one state takes effective control over the territory of another state, then IHL will apply. IHL meaning the Hague Conventions, 4 Geneva Conventions, and where applicable, where states have ratified it, to the 2 additional protocols. If we can move on, Helen, please. Thank you. So when is there an armed conflict between states? The commentary of the Geneva Convention of 1949 confirms any difference arising between two states and leading to the intervention of armed forces is an armed conflict. This is the Jean Pictet commentary of the Geneva Conventions of 1952. We, of course, know that Jean-Marie Encart and his team, a very broad team, are publishing the new commentaries, the revised commentaries since 2015, and every year publishing new commentaries. So anyone interested in IHL and its developments, I would warmly recommend studying the new commentaries as well as, of course, the classic Pictet commentaries. I'll just say that we're very proud that the commentary on the first Geneva Convention, when Jean-Marie Encart was doing his world tour for the publication of it, his first visit was with the ICHL clinic at IDC in Herzliya, in cooperation with the ICRC office in Tel Aviv. So we were very happy to be able to do that, and I believe the second destination was Sweden. So something that might be more difficult to do now in the COVID area, but we hope that soon this will be behind us. Ellen, if you can please press another arrow so we can see the rest of the text. Thank you. Wonderful. Now, the International Criminal Tribunal for Former Yugoslavia, ICTY, which is wonderful. The case law of international criminal tribunals is really the place to learn about the application and enforcement of IHL in practice. In the Tadic case, the very first case, you'll have the reference. If you can press just once again the arrow, please, and you'll have the full reference. The ICTY stated, an armed conflict exists whenever there is a resort to armed force between states. quite simple, apparently. But again, as I said, as the example for cyber, it's never that simple. Even when the text is clear and concise, as under the Vienna Convention, interpretation can be challenged. Yes, so if we can move forward, please, Ellen. Wonderful. I just wrote another source if you're interested, the 2008, I believe, interpretation by the ICRC. So when is there an armed conflict in non-international armed conflicts? Here we have a more difficult question. We need a certain threshold of hostilities. Common Article 3 of the Geneva Conventions, the 4 Geneva Conventions, applies to armed conflicts not of an international character, meaning when not both of the belligerents are states, only one of them, or at least one of them, occurring in the territory of one of the high contracting parties. Actually, it could be on the territory of two or more high contracting parties, but the idea is that the belligerents, the parties taking part in hostilities, are not limited to states. An armed conflict is not less serious forms of violence, such as internal disturbances and tensions, riots, or acts of banditry. The situation must reach a certain threshold of confrontation. So what are riots and acts of banditry? What law applies? Not IHL, not the laws of armed conflict, but law enforcement. So international human rights law, emergency limitation of international human rights law, and so forth. Ellen, if we can move forward. Thank you. So what? Now, in the definitions, we defined IHL very briefly, really on the tip of the fork, as they say, or tip of the iceberg. And now we'll define very briefly business and human rights. It is the field pertaining to how corporate entities are involved in violating basic individual rights. So it talks about what the situation is, and how they should, and corporations should and must act to protect human rights. So what should be? So this is what we want to happen. It's actually by applying, BHR works by applying existing normative frameworks and binding laws, but also by creating incentives for new initiatives, new laws, from soft law to binding law. BHR works, Business and Human Rights works, looking at prevention, to protection, and to remedy. So the sources that we have, the main sources, we have the United Nations Guiding Principles on Business and Human Rights in 2011 by the Special UN Rapporteur John Ruggies. He left us with a wonderful guiding principles to work with, and he's still very active in the field, thankfully for all of us. They talk about the UN guiding principles on business and human rights are divided into 3 parts. The first part talks about state obligation to protect its citizens from corporate violations or from violations by corporations working or operating within their territories or with their territories. The second volume talks about corporations' obligation to respect the law, which no one is above the law, not states, not heads of state, especially not when pertaining to universal prohibitions applicable to all, erga omnes, and international, universally recognized international crimes. So the second volume is the obligation to respect, and the third volume is the right to remedy of victims. And of course, this is an ongoing, let's call it an achievement, but it's an achievement to be. We want to see it as an achievement. We do have good practices. We do have a few good cases, but the momentum now is to enforce existing norms. It's the work of lawyers and attorneys and law students to forward this field, both scholars, academics, and practitioners. And we have actually very good new case law that is arising alongside, unfortunately, less good case law around the world. So for remedy, we can think of international entities, regional organizations, but mainly, as always, the most effective within domestic jurisdictions, knowing that international and regional jurisdictions should operate only when domestic jurisdictions, to fill in the gaps. The ideal world would be that national domestic jurisdictions, they do the work themselves. They're within a democratic structure or some sort of other governance structure, but that makes sense to the citizens, including in the application of law. We also have the Global Impact Network, which sits under the Office of the High Commission of Human Rights in Geneva. We have the Draft Treaty on Business and Human Rights, with the most recent draft, I believe, in 2020, but there might be a newer draft out there. The OECD, so that's a regional economic, not exactly regional, let's say Western economic organization, has its own guidelines on business and human rights, strongly inspired by the UNGPs, the UN Guiding Principles on Business and Human Rights. And we have the EU framework as well as another example of a framework for the application of business and human rights. I'm curious to know what exists in the Inter-American region under its human rights law framework. So if we can, I'd be happy to hear from the moderators if you know about that. One recent example, already dating from 2017, but it's still very young in the use, is General Comment number 24. General Comment is what UN treaty body committees, human rights treaty body committees issue in authoritatively interpreting the articles of human rights treaties. So this is a general comment by the Committee on the International Covenant on Economic, Social, and Cultural Rights. It's General Comment number 24, issued in 2017, called on state obligations under the International Covenant on Economic, Social, Cultural Rights in the context of business activities. So this is to give you a general framework of and also sources to look back to whoever is interested. And from there you can find other sources, of course, applying these key sources. So if we can move forward. Great. Now there's an issue here. IHL is binding on states. That's the problem. I mean, it's not a problem that it's binding on states. The problem is it's not directly binding on corporate entities. Nevertheless, corporations have obligations and cannot violate international human rights law or international humanitarian law in total impunity. So let's say the problem that corporations are not signatories to treaties, even though non-state actors are now the focus, the target of different initiatives to bring them on into treaties, such as one initiative is Geneva Call. It's a very interesting initiative working with armed groups that are not states to join IHL treaties. But we're talking about corporations. So this could be applicable to private militaries. Maybe Elena will be able to talk about that in her talk next week. But the answer to accountability cannot come from IHL alone. Accountability for violations of basic rights. In the context of armed conflicts, violation caused by corporation. We need another law to apply in order to find the response. And usually what we find is really domestic laws, applying international law. I'll give a few examples very briefly very soon. But we need civil law, and we need criminal law, and we need corporate law. So domestic laws that recognize that corporations and the individuals standing behind corporations have to be accountable for specific actions or even omissions when there is an obligation to act and the corporation and its stakeholders or decision makers did not act. So we need to find this, the work of practitioners is really to make these worlds meet between the normative framework and the enforcement framework. That's really the challenge today, and we see many initiatives growing as we speak, actually, in the past 10 years at least. However, or nevertheless, this topic is not new. We've seen one example in the 1945 to 1947 Nuremberg trials, a very well-known example of corporate liability or individuals standing behind these corporations, although these corporations were named by the Nuremberg tribunals, the international military tribunals following the Second World War, and putting to trial the major war criminals. That was the name of the major Nuremberg trial. But after the major Nuremberg trial, there were 12 other trials that proceeded. One of them was against IG Farben and Krupp companies. The IG Farben and Krupp trials namely had to do with forced labor, but also with providing the gas, the deadly toxic gas for the gas chambers in the commission of genocide and crimes against humanity in the gas chambers. So on one hand, we're talking about a new field. On the other hand, it's not really new. It's really a question of where we put our imagination to and our skills. And I believe it's absolutely possible. Very recently, a year ago, with COVID restrictions, time is a bit more fluid. The Canadian Supreme Court reached a very important decision in what is called the Nevsun case. Nevsun is a mining company in Canada, based in Canada, and it worked in Eritrea. Very briefly, because our time is already short, I'll just say that, and excuse the slogans, but it's known as the North Korea of Africa, of the African continent. Widespread slavery of a whole tranche of its male population between the ages of 13 to above 50, under the masquerade calling it military service, but actually taking these individuals away from their families and communities, hundreds or tens of miles away, not seeing their families sometimes for 30 years, for forced labor and slavery. And so a few of the victims brought a case against the Nevsun case. Eritreans brought a case against Nevsun before Canadian courts, and this case has been going on for many years. The main challenge, which is always the main challenge when you sue corporations, or almost always, majority of cases, are the questions, preliminary questions that have to do with jurisdiction, for example, extraterritorial applicability of domestic law. And in the Nevsun case, a major question was, when there is a customary law prohibition, such as the prohibition of slavery, which sees no exceptions, it's a jus cogens rule, this must trigger tort liability. This is what the Eritrean plaintiffs contended, and the court, after many rounds and appeals and retrials, etc., finally ruled in favor of the applicants, and Nevsun and the petitioners reached a settlement. It's confidential, but this is what usually happens. Many years of litigation on preliminary questions, including on questions of jurisdiction, and in case of a win for the plaintiffs, usually companies settle and under confidentiality. Ellen, if we can move forward, we'll go quicker now. We're really in the crux of it, and now I've laid down the basic issues, mainly the challenge of closing the impunity gap and how to enforce jus cogens international norms in domestic settings in the absence of explicit domestic laws. So we have universal crimes, but they're not always written down in the, sometimes they're written down as crimes under the domestic criminal law, but they don't always bring about tort responsibility. So in a civil case, where victims can receive direct remedy. Different jurisdictions provide different answers, and we'll see a few answers now. So Ellen, if we can move forward, please. So when do business meet armed conflict and or belligerent occupation? First, I'd like to state very clearly that in the international framework in the sources that I named before, the connection, the intersection between business and armed conflict, in business and IHL, is recognized. There is no dispute there. So one example is in the preamble, two examples in the preamble and in Article 16.5 of the draft UN Business and Human Rights Treaty from the draft from August 2020. The preamble reads, mentions twice that the interpretation or interpretation of these articles shall be consistent with international human rights law, but also international humanitarian law. If we can move forward, Ellen. A second framework, normative framework that recognizes this, and if you can press it once again, one more click. Thank you, perfect. Is I mentioned it before, the General Comment 24 of 2017 of the UN Treaty Body, Human Rights Treaty Body Committee for Economic, Social and Cultural Rights. In its Article 40, it states, the guidelines on remedies for victims of gross violations of international human rights law and serious violations of international humanitarian law provide useful indications as to the obligations that follow for states from the general obligation to provide access to effective remedies. So these guidelines that are mentioned in Article 40 are guidelines, if I'm not mistaken, from 2005, led by the late Professor Sharif Bassiouni, on the right of victims for remedy for violations, including for violations of international humanitarian law. And in 2017, their force is recognized and reconfirmed once again. So if we can move forward again. Now we'll go to more the practice, now that we really set the base, the normative framework. How do corporations violate IHL? So here are potential case studies, just like in general. We have the setting. The setting is a conflict zone. So for example, a zone that is controlled by militias, or it could be state military. Militias, for example, in Eastern Democratic Republic of Congo. State military, for example, military of Myanmar, who was committed, I know we can say alleged, but I will say is committed or is committing genocide against the Rohingya Muslim minority. And what are the crimes we talk about? We talk about forced labor, child labor, torture, gender-based sexual violence. And here, international criminal law could come to the rescue. We'll see it in a bit. Another setting is when it's actually very linked, but it's a different way to perhaps articulate it. Multinationals controlling either they're controlling land or they work in cooperation of state or militia actors for profit. Now, this is the main thing. When usually, not always, when corporations violate individual rights, when they commit or when they are conspiring to commit, they're aiding and abetting international crimes, they usually don't have some kind of ideology against the population they are responsible for their massacre or torture or atrocious crimes. What they see is profit, because that is the essence of a corporation. Nevertheless, this is not always the case. For example, if we have the case against the Arab Bank in the US for financing terrorism, and part of what the plaintiffs brought to court in the US in the proceeding that prolonged for over 14 years was the ideology of the founders of the bank, and from its founding in the 40s, I believe, and also afterwards in repetitive statements supporting international terrorism. So when they were financing international terrorism, it's the issue here wasn't, maybe profit wasn't the major motivation, but it was more because you always need a mental element when committing a crime, right? So the element here was maybe ideological, but usually it's for profit. So commission of crimes and exploitation. We see it with blood diamonds. We see it in mining companies in conflict zones and so forth. The third scenario or second scenario is private military entities. They have direct participation in armed conflicts. The fourth scenario I thought of was asylum seekers as a public to reach out to, because they fled conflict they are victims of international crimes, many times where corporations were involved, either crimes committed in their countries of origin. They are the most vulnerable populations back home, but they're, of course, once they begin in their voyage. So they are the most vulnerable population or vulnerable to slavery and human trafficking in countries of transit. So one example, very blatant example, are the slave trade and torture camps in Libya that are under the International Criminal Courts in The Hague's jurisdiction and investigation as we speak. Ellen, if we can move forward, please. So this is one example about mine companies in Democratic Republic of Congo. In 2010, there was some hope that the ICC prosecutor then, Luis Moreno Campo, would issue an indictment against the mostly Western mining companies, at least not DRC Congolese companies. Maybe some of them were also, when I say Western, it just means like the companies were not in the continent of Africa, but it could be inter-American companies, it could be Asian companies or other companies. It doesn't have to be Western companies, but these companies are responsible for, as we see in the picture here, widespread crimes committed against children in conflict, men and women in conflict. If we can move forward, unfortunately the indictments in the DRCs for now do not include indictments that have to do. None of them are against corporations. At the ICC, corporations cannot be held responsible because they were explicitly excluded from responsibility. But in Nuremberg, we had the criminal enterprise, a corporation that was criminal in its essence, and therefore any member, like the Nazi Party, was complicit to the crime. In the Rome Statute of the ICC, the International Criminal Court, corporations are excluded from liability, and responsibility is only of individuals. So even though an indictment won't be directly against a corporation, it should be against the decision makers in that corporation. A second example is the Rohingya genocide in Facebook. So you see in small writing, the UN is investigating Facebook's role in genocide of Muslims in Myanmar. Here, the Facebook has a dual role. It should be stated. One, suspected of, as you see under investigation, Facebook that served as a platform for incitement to genocide, but also operatively to commit genocide. It was largely used and exploited by military agents of Myanmar army, military, to organize and to carry out attacks. The other role of Facebook in this scenario is to cooperate with the investigations. The UN is investigating it's a mechanism. It's called the 3 I's and an M, the Independent Investigation of Myanmar, Inquiry of Myanmar, sitting in Geneva. And there Facebook is widely cooperating with the investigation. So it's also providing evidence against the direct perpetrators. So a dual role there of a corporation. And of course, there's a question if this is an armed conflict or not, but I did want to bring this example to the field. Ellen, if we can move forwards, please. We're almost reaching an hour, so I'm really finishing very soon to leave time for questions. Corporate contribution. So how do corporations, after seeing the examples, in terms of a framework, corporations, they contribute to crimes either directly, in the case of private military companies, or they are complicit, or they are guilty of aiding and abetting the perpetrators. This is usually the scenario, aiding and abetting the perpetrators. So we'll see this in the final example I'll talk about, which is the example I am personally involved in as an attorney. Ellen, if we can move forwards, please. And you're doing wonderful work, Ellen. Thank you very much. I promised to talk to you about two angles. One, the prevention. So one example of prevention is the 2003 Kimberley process for conflict-free diamonds. The Kimberley process is a voluntary initiative to receive UN authentication of diamonds, of the source, and to have transparency of diamonds, so that no diamonds reach the markets, no diamonds that are sourced in conflicts, or what we call blood diamonds, reach the market. Today, 99.8% of worldwide trade in diamonds is free of conflict. There is actually, by the way, a study, a PhD that was written and then published on criticizing the Kimberley process. You might want to read something called Did the Lion Roar? Kimberley Process. It was published in 2017 and it's updated to 2015. The study acknowledges the achievements, but also criticizes, nuances the hailing of success. But still, no doubt, the Kimberley process, which joins governments, international organizations, private corporations together, has made a major difference in the diamond market worldwide. So this an example for prevention. And finally, Ellen, if you can move forward, please. Protection, remedy, litigation, victim representation. So as I said, the other side of the coin. So not only international humanitarian law, that's a normative framework. It can also be international human rights law, which is not the topic of today's talk, but these are the normative frameworks. Now we need to see how we can enforce these norms. And the answer can come from civil law or criminal law or corporate law. But in any case, litigation. The case study I would like to briefly present is a case I am working on for the, I don't work on this independently, I work on it for MM Law LLC, which is an American-based, Chicago-based law firm dedicated only to the representation of victims of international crimes, including international terrorism, crimes against humanity, war crimes, and genocide. And anything I say here, actually throughout I should have said this disclaimer in the beginning, is I'm speaking in my personal capacity. It does not represent MM Law or any other entity I work with, except for the clinic at IDC, which is, of course, what's bringing us together today. So what's the story there? Very briefly, the facts in less than 1 minute. We're talking about the chemical weapon capacity of Saddam Hussein's regime in the 80s. And you might say, wow, that was a long time ago. But the chemical weapons capacity was made possible by EU-based companies in France, in Germany, in Austria, and in the Netherlands, and in many other places in Italy, and so forth, including with the aid of bankers and others, knowingly so, without European-based companies that are highly specialized in chemical weapons engineering, both in the substance of chemicals and also in the equipment and also in building infrastructure in Iraq and transporting chemical weapons, something that is very difficult to do. It has to be done in under 20 degrees. I mean, very, very difficult to do. Would not have been possible without the express intentional collaboration of these companies. These weapons were used to commit genocide against the Kurdish community of northern Iraq, and namely on 16th of March 1988 in Halabja. The attacks against Halabja, where the Iraqi military bombarded Halabja in view of erasing it, and there's a statement that the aim of one of the decision makers, one of the generals, saying that they want to wipe out all men, women, animals, and also livelihood, including plants and everything. They did. There were at least 5,000 direct victims, and today law is representing 7,734 victims, Kurdish victims. They're doing this both in, and I'm very proud to be part of it and to be able to contribute to their initiative that they've been doing for many years, since 2013 at least. They're doing it in two main channels. One is a criminal case where the victims are represented as what's called partie civile, which I believe exists in Latin jurisdictions as well. So maybe it exists in Brazil, I don't know. But where victims can be represented directly as civil parties to a criminal case. They can trigger an investigation by filing a complaint to the general prosecutor, who will and the inquisitory judge, investigation judge, who will initiate the investigation and hopefully reach an indictment, and then the trial begins. So we're in the phase of investigation since 2013. The investigation is secret, so I won't say anything else about that. Another channel is through the civil litigation in Halabja itself, in Iraqi courts since 2018, and it's the indictment includes the names of corporate entities that at the time violated 1984, 1986, 1988, violated their own domestic laws, regulations prohibiting exportations of double use, meaning substances that could be used for civil means, but also for chemical weapons, specifically with Iraq, because of course everyone knew who Saddam Hussein was, and therefore they knew what the consequences would be. So this is what I have time to tell you about. With the time that we have, I really would like to leave time for questions. On one hand, I gave the general framework, the main sort of points to look at, the main challenges, and also the remedies, where to find the remedies. And I attempted to bring a few case studies to make things be more practical, and real. So now I would really be happy to hear anyone having a question. And Isabel and Ellen. First of all, thank you very much, Ellen, for your wonderful. Ellen, thank you for mastering it. Wouldn't be able to do it without you. Thank you.
So first of all, we'd like to thank you for your lecture. It was very interesting. And when you think about armed conflicts at all, we barely think about the role of enterprises or private actors. So it was a very interesting research. And I'm sure everyone is happy to hear from you. And we're going to move on to questions. We have a few questions. So I'd like to ask if you prefer to answer one by one, or you prefer me to read 3 questions and then answer them?
Yes, perhaps 3 questions. Before I do, I'll just say that there's another treaty I didn't, there's more direct treaties to do with armed conflicts, such as the Arms Trafficking Treaty, which aims to limit the ability of states to sell weapons so that they don't get into the hands of militias terrorist groups, and so forth. And also the Wassenaar Treaty that has to do with drones and other weaponry. But you'll hear about that probably 1st of July. So yes, Ellen, three questions at a time sounds great. I'll do my best.
Okay, so I'll start. The first one is, how do you evaluate the current business and human rights instruments, such as the UNGPs, the UN Draft Treaty, and the human rights due diligence laws, as properly dealing the specificities of a conflict affect environments? The second one is, how should IHL be more included in BHR discussions, and how to enforce corporate compliance without a legally binding instrument? Is a separate and specific treaty necessary? And the third one is, there is an ideal collaboration model between domestic jurisdiction and international jurisdiction.
Could you repeat the question, Ellen?
Oh, okay.
Okay, great. Let's see.
The first one
is there an ideal collaboration model between domestic jurisdiction and international jurisdiction? Okay, ideal collaboration. And the second one, sorry, good thing that you wrote it, but it disappeared. It was how can IHL issues be better inserted in the BHR discussions? Right, we're talking about the discourse. Is a separate and specific treaty necessary? Okay, I'll start actually with the second question by saying I don't think a separate instrument is needed. As I read out in the preamble in Article 16.5 of the draft UN Business and Human Rights Treaty, the normative framework of IHL, as well as international human rights law, are seen as they are the platform. So they are the base for any of the principles that are agreed upon in the treaty. So they cannot be read separately from IHL or international human rights law, and sometimes not or but and, because of course they also have joint application in specific fields such as detention in armed conflict. So, for example, if detention is done by private entities within the context of armed conflict, then the corporations have to abide by the same obligations that would have been applicable to the belligerents, to the state in detention. So the right, decent conditions, the family visits, in occupation, not to be detained outside the territory, and so forth and so forth. So the second question, I'll just say I don't think a separate instrument is there for now. What I see, of course, this is very, the people who are working on this, working very hardly for years. It's already the setting the norms is a challenge. Of course, we have to wait to the next stage of enforcement, but the minute IHL is recognized as the sort of normative framework, then the interpretation cannot be done contrary to IHL if we're in an armed conflict, and it will have primacy over regular human rights law framework if we are in a if we are in an armed conflict priority. As for the discourse, the best way, of course, I always believe, is participation. Participation and empowerment of specific actors who take part in hostilities, and this should entail states, but also non-state actors taking part in hostilities, and of course corporations that are worried because their activities, either by nature, they have to do with armed conflict. So, for example, in the weaponry section, or by circumstance, like the mining example. So, actors who want to have compliance, and I think today generally speaking, the majority of businesses understand that compliance is better than non-compliance, including in a very cynical, profit-viewed way. Okay, so really participation is the best way to, I believe, to promote discourse. The first question, how do I evaluate existing human rights instruments? Okay, so I think the pioneer, of course, was the UNGPs, 2011. And thank you. A question by Mariana. Thank you for putting it on the screen, Isabel. So it was a groundbreaking instrument. It was a pioneer instrument, and it was the very first significant state that was necessary to bring on the different other frameworks, including regional ones with the EU, for example, but also the national plans and their implementation and enforcement and application in domestic laws. So domestic laws that have sought to apply the UNGPs are, we have right now in Germany, the due diligence law that's being voted. We have the French vigilance law of 2017, applicable from 1st of January 2019. We have the UK Slavery Act, and so forth and so forth. There is great criticism. Let's say there's a cross-board criticism of domestic laws, mainly in the challenge of enforcement, that enforcement isn't strong enough. The French law is seen as the greatest achievement, but I imagine the German law already took that, and I'm still studying it, so I can't say, but the German law already took this criticism into account. The French law really talks about transparency and due diligence, and corporations are accountable not for committing international crimes. So the burden of victims or any entity is not to prove that they had a mental element and a physical element or negligence of an obligation, etc., not to commit international crimes. It's a very great burden to prove. It's sufficient to prove that the company did not have transparent due diligence clauses and so forth. So it's a very sort of procedural approach in order to reach substantive protection of rights. So yes, I hope I answered that question. And the third question, what is the ideal model between complementarity between international and national law, of Professor Valine? Thank you for the question. I think my view to BHR is not different to international criminal law, which is actually my main field of specialization, which is, for me, the ideal model is complementarity. I know certain situations call for primacy. That is true in the past, historically. But I think the world is evolving now to a stable framework of accountability, and a stable framework or a forward-looking framework of accountability, as opposed to an ad hoc, temporarily framework, needs to be based on complementarity, where the main actors are domestic actors. I think I referred to it somewhat in the lecture. That's the ideal world. Within a judicial system of one country, if it works like it should, then we won't need the international system. We won't need international jurisdictions. Reality is we do need international jurisdictions. The international jurisdictions have the advantage of not being part. They're not parties to the conflict, although they also should check themselves. Are they really neutral? Are they really impartial? They don't have to be neutral, but are they really impartial? I mean, they're individuals who have their biases, and of course, we're all human. And a judge in a domestic setting has his and her biases. However, they are part of it. So that's an advantage and a disadvantage. I write about it quite frequently, about who is a better actor, who is more objective, the internal one or the external actor. the internal actor has more knowledge of the conflict and knows to identify falsities more easily. It doesn't mean that the internal actor is always right, of course, but I believe that every national jurisdiction has its own sort of mechanisms that have an historical background and justification. And so justice delivered locally, if it is done genuinely and under the highest international standards of civilized nations, then national jurisdictions should be preferred. Also in view of redemption of something that justice can do, not only punishing but also building a better future, of having former perpetrators perhaps do civil service for the community, a corporation can invest its profits in the community for reparations, for long-lasting projects, for educational projects, and so forth. When the national jurisdiction does not work, then of course the international jurisdiction must work, because certain atrocities humanity has already agreed, mankind has already agreed. How do you say? They shock the conscience of mankind. So of course international jurisdictions are needed.
Perfect, thank you. Then moving on for the next 3 questions. Leticia Heinzmann has asked, what is the difference between individual responsibility and corporation responsibility? And what are the possible consequences that may arise for corporations that disrespect IOGL? The second question from Julia Bergman is, considering ICL applies to individuals, can it be applied to violations committed by corporations as well? If so, it ultimately mean individual responsibility of persons behind the corporation? And would that be similar to the doctrine of command responsibility for individual responsibility of military commanders? The last question from Felipe is that if the Rome Statute criminalizes use of poison, would corporation producing chemical weapons, not only government and armed forces officers involved in their use, be held accountable before the ICC?
Great, and also great work of putting together questions that are related to each other. So I'll try and answer the 3 questions that are related. I might miss something, so if I do, especially Julia's point on command responsibility, I'm not sure I fully understood. I will first answer, and then if I miss something, then please feel free to come back to me. The difference, the first person who asked the question, Ms. Heinzmann, I think, Leticia, yes, Heinzmann. Thank you for the question. Individual responsibility versus corporate responsibility. So you were wise and you didn't limit it to individual criminal responsibility or corporate criminal responsibility, but individual responsibility. So an individual can answer to, in general, civil responsibility or criminal responsibility. He can be held liable. And also under corporate law. Corporate law, okay, so the thing is, let's say everyone is responsible, that there is individual responsibility and corporate responsibility. Corporate responsibility depends on corporate law and how it is, how a jurisdiction defines a corporation. Is it an entity that can stand trial or not? And different jurisdictions, some jurisdictions say it can, and a corporation has rights and obligations, and some say that it cannot, or it can do so partially. Now, the main issue is really the sentencing. It's the issue is twofold. One is the mental elements. So if we're talking about criminal law, you need to have an intention. You cannot commit a crime when you didn't intend to commit it. And so what is the intention of a corporation? The intention of the corporation is the intention of the individuals that stand behind the corporation. So it's like at the Nuremberg trials, the judges in the judgment stated, when talking about individual criminal responsibility, they stated, states are not abstract entities. Crimes are not committed by abstract entities, meaning states, they are committed by individuals. So the same goes for corporations in that sense. We do have state responsibility in international law and zero state responsibility in national law. So it's not a perfect fit. Back to corporate responsibility. So we said twofold. One fold is the mental element. And can we say that the corporation, as a corporation, had a will to do something, a wish to do something, an intent, a knowledge? Individuals have knowledge, individuals have intent. The other issue is the sentencing, because for crimes, people go to jail, and a corporation cannot go to jail. So how do we overcome these two elements? One is to insert in when we talk about criminal law, of course, calls for strict interpretation, nullum crimen sine lege, so principle, meaning if there is no law, there is no crime. So there has to be an explicit law pertaining to corporate liability. It's not something that can be interpreted just like that. Civil law is different. Civil law is, large interpretation or not. It's not bound by strict interpretation. And if you combine corporate law and civil law, then corporate law that acknowledges the raising of a screen, is that how you say it in English? The fact usually the corporation shields the individuals from, let's say, debt in money. So you can raise the shield. I don't exactly remember the phrasing now. So you can, if corporate law acknowledges raising this screen, then it can do so also for tort liability, but it cannot do so for a criminal law, because that has to be explicit. Intent or knowledge can really be proven by documents that are issued by the corporation. Now, there are individuals who represent the corporation, and that's a legal construction, but it does exist and it is applied. So the major stakeholders, the decision makers, the directors, etc. Now, what can be the sanctions for a corporation? We have sanctions. They can, even for a crime, for criminal responsibility, it can be reparations, so paying sums of money, or it can be individual reparations, collective reparations, in actions or in money. And it can also be the prohibition of activity. So this is what the Court of Arnhem, in 1984, there was an indictment against Heidelberg, one of the corporations that are sued in the case of the chemical weapons in the Saddam Hussein case that I talked to you about in the Halabja attacks. In 1986, the Court of Arnhem convicted the corporation, and it was of violating an internal regulation, deliberately, and violating exportation limitations, delivering chemical weapons knowingly to substances to Saddam Hussein's regime. And they were prohibited of activity for a year or 2 years. This was in 1986. The Halabja attack was in 1988. Other corporations continued to act. They're just neighbors, bordering neighbors, but you can imagine what could have been the life-saving consequences if this would have been the ruling in other of the jurisdictions in France and Germany and other places against these corporations that continue to act. So this was for the Laetitia. I hope I answered your question. The second question came from Julia, and thank you for your question, Julia Bergman. Considering ICL applies to individuals, can it be applied to violations committed by corporations? So yes, and actually this joins Felipe's question. Would that be similar to the doctrine of command responsibility for individual responsibility of military commanders? Okay, so the doctrine of command responsibility for individual responsibility of military commanders has to do with what the commander knew or had to have known. It's the closest. Usually, you need a dolus. You need a dolus. You need the will, the intent, the mental element. And in international crimes, dolus eventualis, meaning neglect, it doesn't bring a responsibility for international crimes. You can't commit an international crime by neglect. However, if you had a legal obligation to command, to prevent crimes, like the commander has over his troops, either his troops de jure or his troops de facto in the field. And in the Rwandan court, the ICTR, there was even a singer who was convicted under command responsibility for moving the youth to commit genocide. Okay. So the commander has responsibility for actions, but also for omissions. You can read the ICTY case law, and you can read a wonderful chapter written by Christopher Gosnell, Damned If You Don't, Command Responsibility by Omission. I don't remember in what book it was published. So could corporate liability be for neglect or for omissions? That depends on whether the corporation had the obligation, like it has on its troops, a commander has on its troops, to act and to prevent. Now, seeing that there is a hierarchy between the corporation and its employees, then it is an envisageable, it is a doctrine that could be applied in theory. Yes, it would have to be, of course. It's a very good direction. If we can go back to the beginning of the question, Julia's question, the difference considering ICL applies to individuals. Okay, so you know what? I'll answer this when I answer Felipe's question. If you can jump to Felipe's question, please. Thank you. Thank you, Felipe, for your question. So the Rome statute criminalizes use of poison. Could corporations produce it? Okay. Now, let's take
It seems like we are having some technical problems. So let's see if we may reach our guest.
Oh, here we are. Here we are.
yes,
Sorry. Sorry, everyone. Okay, we're back.
problem.
We're back. Good. So the Rome Statute, the universe is stating, we're going out of time. Rome Statute criminalizes use of poison. If I'm not mistaken, it's a war crime under the Rome Statute. But we can think about intentional killing, targeting of civilians, and so forth. I'll talk about your idea, Felipe, under the realm of crimes against humanity. Because crimes against humanity, and then the answer is yes. It's not the corporation that's accountable, but it's one element that is needed to bring to the liability of the individuals that stand behind the corporation. I'll explain. Crimes against humanity under the Rome Statute, Article 7, entails a few elements. The chapeau, the chapeau elements to be constituted. There needs to be a widespread or systematic attack there needs to be an attack against the civilian population in knowledge of the attack, okay? And it is part of, if you read elements of crime under the document under the ICC, elements of crime defines the policy. Widespread is from a policy. The policy can be state policy or an organizational policy. And so in the beginning of the ICC, there was broad debate. Not everyone accepted the fact that non-state actors could commit crimes against humanity, but today it's a given. States or individuals standing behind abstract entities such as states can commit crimes against humanity, and individuals standing behind abstract entities such as organizations, such as corporations, can commit crimes against humanity. So that would be the applicable framework for corporations, just as non-state actors are on trial today before the ICC. Non-state actors can be armed groups and they can be corporations, definitely. Yes.
So thank you very much, Yael. And I must ask you if we have time for 3 more questions.
Sure, let's do 3 more. You've been the listeners have been so patient, and I'm so sorry I can't see who's listening, but I know you're there, so I'll be happy to 3 more questions. Let's do it.
Okay, and the first one is, what degree of aiding and abetting is necessary? Is there a threshold? And you mentioned that Facebook in the Myanmar case facilitated communication between perpetrators. Is that enough? The second one is, considering the debate on social media, companies' duty or responsibility of moderating content in their platforms, what constitutes? Could failing to ban potential perpetrators meet some kind of threshold? And the last one is, in America, foreign companies tend to collaborate with military dictatorships. For example, Mercedes in Argentina and Volkswagen in Brazil. How can we avoid this type of collaboration in the future?
Thank you, Gabrielle. So wonderful questions. And unfortunately, the time is a bit late, so I'd really appreciate seeing the text in front of me. It'll be easier for me to reply. The first question by Julia. So you have wonderful questions, Julia. Thank you. What degree of aiding and abetting is necessary? Is there a threshold? To have aiding and abetting, of course, it depends. There's a discussion on whether there is a customary threshold of aiding and abetting in international law or not. But in general, or let's say we talk about the ICC, and the ICC and the ICTY aren't similar on this, because ICTY works on joint criminal enterprise theory 1, 2, 3, like different stages of what part are you in the joint criminal enterprise. But the ICC works differently. The ICC works on, there's a common plan, and then different contributors to the common plan, and the different contributors, so the aiders and abettors, they need to, for example, have the intent, and they need to have the knowledge. So if they know, so the debate is really, did they know or did they not know? We will contend that they could not have not known when working with providing chemical weapons to Saddam Hussein. They could not have not known that, he's a dictator who has already committed genocide and mass massacres, and so you're providing him now with chemical weapons. Chemical weapons are always banned. They're always prohibited. Their use is always illegal. You cannot sort of make chemical weapons and that their use will be legal. That's you have the Convention against poisonous weapons, etc., that was in force against the use. So the use was already prohibited in 1988, and they were contributing to the use, because without their help, there could not have been the prohibited use. They need to know, and they need to have, when you know, you do it deliberately. It doesn't mean that you profoundly want the people to die, but you can't say, okay, let's do it, and I don't really want them to die. I mean, it doesn't make sense, right? So it has to be the psychology of a reasonable individual. Facebook in Myanmar case facilitated communication between perpetrators. Is that enough? That's a good question. So that actually brings us to the responsibility of Facebook, and it's a big question that's going on in courts today. And I think, if I'm not mistaken, did Julia have another, was there another part of this answer, or that's a separate question, or that's a separate question? Here, considering the debate on the social media companies' duty, responsibility, moderating conduct in the platforms, what constitutes good failing to ban? Okay. This actually has to do with a case I'm preparing, so I hope I'm not sort of kicking my a home goal, right? Of course. So I'm talking generally, not to a specific case, and any case, has to be debated very specifically. The question of responsibility of what is published on a platform is a big question in case law around the world. And the answer varies with the acts. Okay, so with some acts, Facebook or social media are like the newspapers, and then the newspaper is liable for content. And in other acts, it's not exactly the same thing. Also, different examples. Let's not talk about crimes here. Let's talk about defamation. So defamation, on the question of, let's say, where it's being published, when it's on social media, defamation is the whole wide world. That's what jurisprudence said, case law says, more or less. Whereas, for example, intellectual property, it happens in the place that it has the most effect, even though it's the same platform. Facebook here and Facebook there, but the acts are different. So when we talk about incitement, it depends what we're talking about. Incitement to genocide is an international crime in itself. Incitement to violence or to racism, to commit crimes, depends on domestic laws. In Israel, for example, incitement to hate is criminalized only when there is a result. So when there's a hate crime that was committed. Whereas hate crime is like genocide in Israeli law, but incitement to violence, not just hate racism, but racism is prohibited anyways. But incitement to violence is prohibited only if there's a result, and that there's a link between the incitement and the result. So the extent of the duty, responsibility of companies varies in relation to the acts that are contended. So, for example, if we talk about international terrorism, you have treaties and you have domestic law talking about the prohibition to contribute to terrorism in any way, including by financing. You have a treaty on financing of terrorism. But, for example, in domestic law in Israel, there's a law against law fighting terrorism of 2006. Then you have an article stating it is also prohibited or criminally prohibited to the diffusion of incitement to terrorism or recruitment of terrorism or in any way assisting terrorism operationally. So there, Facebook could have responsibility. So that's just an example, right? But it really depends on the case. Is there another question? Of course, Gabrielle. Thank you. So you ask a very important question, and that brings me to the first issue of remedy, which was on prevention and not on litigation. It's a very important issue. How can we convince foreign companies or companies not to collaborate with military dictatorships or any entity using force illegally or even we're talking about crimes, but it can be we can talk about animal rights, we can talk about veganism, right? We can talk about prevention. So how can we avoid this type of collaboration in the future? We need to understand, my humble view is we need to understand what corporations are. They're entities based on profit, and if their profit will go against collaborating with dictatorships, then they probably won't do it. So here, public sort of lobbying is very important. The sort of the, how do you say, the reputation of a corporation is very important for its profits. So you have car corporations, I won't name names, but their branding is reliability, safety, and so forth. And so if there is, and there was, sort of a problem in manufacturing that brought about caused death, their reputation is tarnished, and they'll have to work very hard in order to sort of correct that reputation. So the same thing goes to the companies that you mentioned. I'm talking generally and not against any specific entity.
Well, perfect then. Our webinar is coming to an end. So we would like to deeply thank our guest speaker, Yael, for sharing her precious time and knowledge with us. It was really an honor and a pleasure to learn from you today. And we would also like to thank all the attendants and for your patience and interest, of course, and inform that this video and this live stream will be available in our YouTube channel, as well as invite you for the continuation of our talk, business rights and for our next talk that we're going to have on the same topic in the next week at the same time. So if you like to be notified, do subscribe to our channel. And that's it. Thank you very much for all of your attendance. Oh yes, this is the poster for the next event with Yelena Yaparachi.
Thank you very much. Thank you very much, everyone. And also the last slide of my PowerPoint had my email. So if anyone would like to reach out after following this, you're welcome to write me on Yael Gman dot or whatever it's called, gmail.com. I don't know if the moderators, if Isabel or Len, you can post it. So really feel free if we can, some topics, if we can continue. If there's questions I couldn't reach, I'd be happy to continue. And I'm looking forward actually to Yelena's, Dr. Yelena Aparachi's, I'm going to be here on the 1st of July. So I hope to see many of others as well. Thank you very much.